Okay, well, we'll get started with our seminar today. Welcome, everyone. We have a few folks in the room and quite a few online, so thank you. It's great to have Dr. Sonali Walpola here visiting us at Melbourne Law School. For those who don't know me, I'm Miranda Stewart. I'm Director of Tax Studies here, a professor here at the Law School. And I'm also, for those who maybe don't know, I'm director of a fairly new research centre called the Melbourne Centre for Commercial Law, which brings together a range of different programs across a very broad set of commercial law, which also includes tax law and policy. And so this is an MCCL seminar sort of led by the tax research program. Please excuse my voice. I hope it's reasonably easy to hear. I would also like, first of all, to acknowledge the traditional owners of the land on which we meet today, which is the lands of the Wurundjeri people of the Kulin Nation, and pay my respects to elders past and present. So Sonali is visiting us from the ANU, where she is a senior lecturer in the College of Business and Economics at the ANU, which she teaches taxation law and commercial law. And although being based in the business school, is actually also widely kind of read and deeply expert in principles of common law and judicial approaches to the common law. It's her other research interest. She's a supervisor of the ANU Tax Clinic and a co-editor of oztaxpolicy.com, which is the blog of the research blog of the Tax and Transfer Policy Institute. So Sonali's research, which I think is one of her sabbatical research projects, is about trusts and anti-avoidance. And as we can tell from the audience online, it's a very topical issue. And in particular, Section 100A, this reimbursement provision. So I'm going to hand over to Sonali. She is probably just going to maybe present the talk. If people do have a burning question, perhaps you could raise your hand online or in the room, but we will have some time for questions at the end of the session. At the end of Sonali's presentation. We probably will be able to circulate the slides later as well. And in terms of taking questions online, if you could put a question in the chat or else raise your hand. Avril here, who's been helping us set up the seminar, will keep track of those people and then there'll be an opportunity to contribute or ask questions. Okay, so with that, I'm going to hand over to Sonali. Thank you.
Thanks, Miranda. Hi, everyone. Thanks everyone who came in person and thank you for all of you listening online. And also thanks to Miranda for enabling my visit here and giving me the opportunity to talk about trusts and tax avoidance. So my seminar is on the specific trusts integrity provision 100A in the 36 Act concerning reimbursement agreements. Since 1979, when the provision was enacted, there have been only a modest number of federal court decisions and one High Court decision on 100A. Although seldom used for several decades, as many of us know, currently 100A is in the spotlight. Last year, the Commissioner released a tax ruling on 100A, which signals an intention to make wider and more frequent use of the provision. And in the last 2 years, we have had 2 federal court cases, Guardian and B-Blood, and the appeal decisions for both were handed down this year. Here is the Section 100A case law, the federal court decisions and one High Court decision, Raffland. The most important decisions in terms of establishing the approach to 100A elements are Prestige, full federal court, and of course, Raffland being a High Court authority, which upheld propositions established in Prestige. With the recent full federal court decisions, the Commissioner was successful in B-Blood, but not so in Guardian, at least on 100A. In my view, 100A has large underutilised potential to address trust tax avoidance. A broad, non-technical approach to the provision was authoritatively laid down by the High Court in Raffland, which upheld Justice Kiefel's decision and reasoning at first instance. I argue that 100A ought to have succeeded on the facts of Guardian, but very strangely, RAFLand was not cited or discussed once in the full court, and there are several other deficiencies with the use of precedents. Before launching into 100A, a few comments on trusts and tax avoidance. The number of trusts in Australia is growing and substantial. Based on recent ATO data, the number of trust returns lodged is close to that of company returns, around 1 million. Discretionary trusts are the most common type of trust, constituting nearly 80% of all trusts. It is the fundamental basis upon which trusts are taxed that creates the opportunities for tax avoidance, tax advantages, I should say, which sometimes constitute tax avoidance. For example, by allocating trust income to tax-preferred beneficiaries, such as an associate without other income or a corporate beneficiary with carry-forward tax losses, tax liability can be significantly reduced subject to the operation of anti-avoidance provisions. And evidence from a variety of sources, commission reports, ATO materials, case law, shows that trusts are often used to engage in tax avoidance, meaning the deliberate use of trusts to reduce tax in ways that are artificial and contrived. In terms of the legal machinery to address trust tax avoidance, we can briefly note two situations where the law does have highly effective, essentially self-executing mechanisms, assuming reasonable compliance. One, Division 6AA of the 36 Act contains economic disincentives to use trusts or other structures to distribute income to minors. These allocations are taxed at deterrent rates above a small tax-free threshold. Second, it is not possible to use trust companies or partnerships to alienate personal services income, as there is a specific anti-avoidance regime in the 97 Act, which requires that the income be included in the assessable income of the individual performing the services. So the scope for unfair tax minimisation is with respect to investment and business income, subject to the operation of anti-avoidance rules. In previous research, I've looked at the Part 4A trust cases. In a nutshell, the general anti-avoidance rule has been a very ineffective tool, mainly because of the challenges in establishing a dominant tax avoidant purpose. So turning to 100A and the legislative text, the operative requirements are in paragraphs 1 and 2 and paraphrased in the slide. The key to applying 100A is identifying that a beneficiary's present entitlement to trust income arises out of or in connection with a reimbursement agreement. If so, then under 100A, the consequence is that the beneficiary is deemed not to be presently entitled to that trust income, and the trustee is taxed on the amount at the highest personal rate under Section 99A. Reimbursement agreement and agreement are defined in paragraphs 7, 8, and 13. The meaning of present entitlement in Division 6 is well established. It means the beneficiary has a legal right to demand payment of a share of trust income. The concept of present entitlement does not require payment or a reasonable expectation of payment to the beneficiary, and so-called unpaid present entitlements arise in practice, which are sometimes associated with tax avoidant practices. The expression reimbursement agreement is much wider than it seems. The definition in paragraph 7 does not require any reimbursement or repayment in the conventional sense. It requires only that any kind of payment or benefit is paid to someone other than the beneficiary. This interpretation was upheld in Prestige and B. Blood. Identifying that someone other than the presently entitled beneficiary gets an economic benefit is the chief mischief that the provision addresses. In 100A scenarios, there's an attempt to separate the tax liability, which has crystallized in the beneficiary, from the economic benefit, which has gone to the entity really intended to benefit, usually an associate of the trust controller. As emphasized in Prestige, agreement is defined extremely widely in paragraph 13, extending to any arrangement or understanding, whether express or implied, whether enforceable or not. The only exclusion is for agreements in the ordinary course of family or commercial dealing. In my view, the case law does not indicate that this is a serious impediment to 100A's anti-avoidance potential, because prestige establishes that it is the arrangement as a whole, not a step or discrete aspect, which matters for this inquiry. Paragraph 8 contains a tax reduction purpose requirement, but unlike Part 4A, it does not require a dominant purpose of avoiding tax. It is sufficient that at least one party to the agreement has a purpose of reducing tax. This is a chief advantage of 100A compared to Part 4A. The requirement that the present entitlement arise out of or be connected with a reimbursement agreement, the so-called nexus requirement, has been interpreted liberally in Prestige, Idlecroft and Raffland, as will be discussed. However, a temporal sequence requirement has been accepted in 2 decisions. In East Finchley, Justice Hill took the view that the reimbursement agreement must precede the present entitlement of the beneficiary. This proposition was accepted in Guardian. However, the point was conceded by the Commissioner in the Guardian appeal. It has never been judicially tested by the court. As my paper argues that the full court in Guardian did not consider salient and authoritative 100A precedents, I'll provide an overview of these cases with the purpose of showing what they established. Prior to Guardian and B-Blood, there were only 4 instances where 100A was relied on as a substantive basis of assessment in court proceedings. These were East Finchley, a 1989 single judge decision of Justice Hill. This is the 100A decision most relied upon in Guardian. Prestige, the first full federal court decision on 100A, decided in 1998. The joint judgment of Justices Hill and Sackville presents an extensive analysis of the rationale of the provision and its elements, and establishes a number of propositions on the meaning of 100A elements, which shows a purposive liberal approach. Despite being a lead authority, the Guardian full court makes only incidental minor reference to Prestige. Idlecroft is a full federal court decision of 2005. It directly dealt with an issue that the Guardian full court raised as relevant, but Idlecroft is not cited or discussed by the full court in Guardian. Raffland is the only High Court decision on 100A, decided in 2008. Raffland shows a broad, purposive approach to 100A consistent with Prestige. It's not cited or discussed in Guardian. The Commissioner's 100A case was successful in Prestige, Idlecroft and Raffland, but apparently not in East Finchley. Okay. It's not actually a final court determination. Hill remitted it to the tribunal. I will proceed in chronological order. East Finchley, being a single judge decision, is the least important of the 100A precedents. And there are even indications from Hill and Justices Hill and Sackville that it should not be particularly relied upon. However, extensive and it is submitted unnecessary reliance was made of it in Guardian. The case involved a discretionary trust controlled by Dr. Thomas. In the income year ended 30 June 1983, some 126 non-resident beneficiaries in India, Thomas's relatives and friends, were each made presently entitled to $585, this amount being tax-free at the time. The beneficiaries were then given a letter to sign which would authorize the trustee to credit their entitlements to an at-call loan account operated by the trustee. No money ever changed hands. The Administrative Appeals Tribunal upheld the Commissioner's 100A assessment. Justice Hill prefaces his judgment by stating that he had some concerns about expressing any view on the legal submissions. That the remitted to the tribunal for findings of fact, but ultimately Hill does express a view. Justice Hill considered the beneficiary's authorization to lend money to the trustee constituted a payment to someone other than the beneficiary as required under the definition of reimbursement. But Hill took the view that the nexus requirement was not satisfied because on the facts, the reimbursement agreement took place after the creation of the beneficiary's present entitlements to trust income. This view was followed by Justice Logan in Guardian at first instance and conceded on appeal. The nexus requirement in Section 100A between the present entitlement and the reimbursement agreement is stated in various alternative ways in paragraphs 1 and 2, only one of which needs to be satisfied. As a matter of textual interpretation, Hill considered that it could not be said that the present arose out of a reimbursement where the reimbursement agreement was subsequent to the present entitlement. However, Hill expressed less certainty, even questioned whether the alleged temporal sequence was required pursuant to the alternative nexus requirement in paragraphs 1 and 2, which only requires the present entitlement to arise by reason of or as a result of any act, transaction, or circumstance in connection with a reimbursement agreement. Despite the expressed doubt, Hill considered without further analysis that even those words required the reimbursement agreement to come first. The fact that Hill expressed a measure of doubt about one nexus variant was not that shortly.
Having a bit of issue with the mic. I wonder, do you want to just swap?
Sure.
You pass me that one.
Yeah. Thanks.
Yeah.
Yeah, so now turning to Prestige, this is an important authority that establishes several propositions as to the interpretation of 100A elements, which are accepted by the High Court in Raffland and applied or accepted in the full federal court decisions of Idlecroft and B-Blood. The taxpayer Prestige carried on a successful motor vehicle business and engineered a complex scheme to avoid tax on its business profits. The taxpayer sold its business to a unit trust which it controlled. Then it issued 93% of the units to a specially introduced beneficiary with carry forward losses. The special beneficiary was controlled by the taxpayer. The beneficiary assigned large debts to another company associated with the taxpayer, thereby conveniently generating an obligation on the beneficiary to pay interest to that associate. With its share of trust income, the special beneficiary did not pay any tax due to its substantial tax losses and interest deductions. The full federal court held that 100A applied. The joint judgment of Justices Hill and Sackville, with whom Justice Beaumont agreed, demonstrates a broad, non-technical approach to 100A elements. First, on the point that was crucial on appeal, the full court rejected the taxpayer's submission that the concept of reimbursement agreement under 100A applies to existing trusts which existed prior to the reimbursement agreement. The taxpayer had supported its contention on the basis that 100A was a specific anti-avoidance provision and appealed to extrinsic materials to argue that Parliament intended 100A to apply to certain trust stripping arrangements pertaining to existing trusts. Hill and Sackville held that there was nothing in the language of 100A to indicate that the trust needed to predate the reimbursement agreement and that it was sufficient that the trust was established as a consequence of implementing the reimbursement agreement. Second, as foreshadowed, Hill and Sackville rejected the taxpayer's submission that 100A required a payment to have the character of a reimbursement in the conventional sense. Their honours relied on numerous authorities for the point that a defined expression can have no meaning other than what is stated in the definition. And here the reimbursement agreement only required a payment or benefit to someone other than the beneficiary. and that was satisfied here, the court pointing to the interest paid by the beneficiary to the taxpayer's associate. Third, the court interpreted the ordinary dealing exception in paragraph 13 in a way that does not undermine its integrity objective. The taxpayer had argued that the agreement should be seen as a transfer of a business from Prestige to the trustee. Hill & Sackville rejected this submission, holding that it was incorrect to focus on one element of the arrangement. Hill & Sackville held that the ordinary commercial dealing exception did not apply, emphasising that it was the arrangement as a whole that should be examined, and concluded that the sale can be seen as one element of a larger one-off transaction designed to avoid tax. In holistically evaluating the judgment of Justices Hill and Sackville, it can be noted that their honours consistently chose interpretations of 100A that further its purpose of addressing tax avoidance. There's a further point to note now, and that is that Hill and Sackville issue a note of caution on adopting restrictive interpretations based on extrinsic materials and obiter dicta in judgments. Pertinently for present purposes, their honours refer to Justice Hill's judgment in East Finchley and caution that while the judgment gives illustrations of trust stripping to which 100A was intended to apply, his honour plainly did not essay an exhaustive collection of such arrangements, and the judgment should not be read as though it did. Turning to Idlecroft, the decision of the full court here matters for present purposes as it is the most direct authority on whether a beneficiary needs to be a party to the reimbursement agreement, being an issue that the Guardian full court raised as relevant, but without reference to Idlecroft. So I'm just going to go straight to the issue with this one because the detailed facts aren't that important to this point. So it was accepted in the full court that the appointment of income to the special tax preferred beneficiary was invalid because it had not been properly nominated as a beneficiary. Then the taxpayers used that to argue, and well, what that meant was that the default beneficiaries became entitled, not parties to the reimbursement agreements. And the taxpayer then argued that 100A did not apply because the taxpayer relied on observations of Hill in East Finchley, which both shows some degree of support for this as a general proposition, and also states that this will certainly be the case, that is, a beneficiary needing to be a party, where the so-called reimbursement agreement is one requiring payment by the beneficiary to the trustee. The full court upheld the Commissioner's 100A assessment in Idlecroft. The court expressed the view that Justice Hill's remarks were directed to the particular circumstances and documentation before him and stated that His Honour was not expressing any general principle on 100A. The full court emphatically rejected that a beneficiary needs to be a party to any arrangement or understanding and held that the expression in relation to a beneficiary in paragraph 7 did not impose any such constraint. The court also takes a liberal approach to the nexus requirement, which I'll outline in discussing Raffland as it was followed there. So turning to Raffland, the characters here were the Heron brothers, who had a property development business. They attempted to avoid tax on their business profits through a specially constituted trust, a discretionary trust, Raffland, which they controlled. With their advisors' help, the brothers purchased an entity, E&M, with large carry-forward losses and made it a tertiary beneficiary of the Raffland Trust. Then one of the Heron's business trusts conferred the Raffland Trust with a $2.85 million entitlement to Heron business profits. The RAFLAN trustee resolved that E&M was presently entitled to $250,000. This was the agreed participation fee to the third-party vendor, and purportedly also the remaining $2.6 million from the brothers' business profits. E&M reported a nil tax liability due to offsetting tax losses. The $250,000 participation fee was paid to the beneficiary, but the larger amount of $2.6 million was retained tax-free by Heron entities. The High Court, upholding Justice Kiefel's first instance decision and reasoning, and in preference to the full court's reasoning, held that 100A applied and that the Commissioner was entitled to assess the trustee on the total purported present entitlements, $2.85 million plus penalties. The full court in Guardian does not discuss or cite RAFLAN once, meaning not at all. RAFLAN is absolutely relevant to any court determination on 100A because the basis for decision in RAFLAN is 100A. And being High Court authority, any Australian court is required to consider it. In evaluating RAFLAN and its significance, in terms of what can be attributed to the decision, it is important to note that the High Court adopts Justice Kiefel's decision and reasoning at first instance, her findings of fact, and in fact provide large extracts from Kiefel's judgment for key conclusions. So Kiefel's judgment is of central importance. Next slide, please. There are several aspects of the High Court's decision and reasoning in RAFLAN which indicate a liberal, purposive approach. Of greatest relevance to Guardian, the High Court's non-technical approach is shown by its acceptance of Kiefel's conclusion that a reimbursement agreement was established, even though, as Kiefel put it, the Commissioner had not identified one or more reimbursement agreements, but only, in Kiefel's words, a series of transactions which purported to channel the funds, at least in a legal sense, from Heron entities to the RAFLAN Trust and then to E&M. Kiefel took a broad approach that was guided by the provision's anti-avoidance purpose. It's important to note that in RAFLAN, a series of transactions is enough to constitute a reimbursement agreement. Kiefel rejects what she termed the narrower approach contended for by the taxpayer, that there should be a close, if not direct connection between a singular understanding or arrangement between two persons and the benefit provided. There are further ways in which the High Court, adopting Justice Kiefel, overcame every potential obstacle to the operation of 100A. The High Court took a liberal approach to the nexus requirement. The High Court agreed with Kiefel that the brothers as default beneficiaries became presently entitled to all of RAFLAN's trust income because the purported present entitlements conferred on E&M were a sham and invalid. Even with the $250,000 actually paid, that was not a trust distribution, but a participation fee. Now, this was a potential problem, as usually in 100A scenarios, there's a separation between present entitlement and economic benefits. However, the High Court agreed with Justice Kiefel that 100A nonetheless applied. On the same reasoning, in fact, used in Idlecroft, and that was that the brothers' unintended present entitlements arose directly as a consequence of the invalid appointment of income to E&M, which was made pursuant to a reimbursement agreement. The High Court also accepted Justice Kiefel's innovative approach to identifying a benefit to someone other than the beneficiary. It took the form of a non-payment. The fact that one of the brothers' business trusts, which resolved to confer $2.85 million on the RAFLAN Trust, would never actually be required to transfer the bulk of this, only the $250,000 participation fee. Okay, so coming to Guardian. In Guardian, the key factual elements are that the trustee owns all the shares in a corporate beneficiary. The trustee creates a present entitlement in favour of the beneficiary. Then the beneficiary declares a franked dividend in favour of the trustee. The arrangement is repeated in the following year. The apparent tax benefit is limiting tax to the corporate rate. Now, in terms of the specifics, Springer is the controller of the AIT Trust, which had been established in the 1990s to conduct his businesses long before the events relating to the tax controversy. Springer owns all the shares in the corporate trustee, Guardian. In 2007, Springer began transitioning to retirement and then moved to Vanuatu for personal reasons, becoming a non-resident. In 2012, a new corporate beneficiary, AITCS, was introduced. Justice Logan, at first instance, accepted this was to satisfy Springer's desire for a clean skin investment vehicle that was immune from risks associated with his former businesses. The trustee Guardian is the sole shareholder in AITCS. At all material times, the directors of Guardian, the trustee, and AITCS are Springer's son and Springer's trusted business associate. In terms of the series of steps undertaken, in June 2012, the trustee made AITCS presently entitled to a substantial amount of income, trust income, which was unpaid. Then in 2013, AITCS draws on its unpaid present entitlement to pay tax. Then it declares a franked dividend to the trustee in the amount of the balance, which offset its unpaid present entitlement to nil. This arrangement is repeated in the 2013 income year. In June 2013, there's an unpaid present entitlement to AITCS. Then in 2014, AITCS draws on its unpaid present entitlement to pay tax. Then it declares a franked dividend to the trustee, which offset its unpaid present entitlement. In both years, the trustee Guardian sets aside the dividend absolutely for Springer as a non-resident, it's non-assessable, non-exempt income, the franked dividend to a non-resident, and so no further tax is payable. The Commissioner assessed the trustee under 100A and issued alternative assessments based on Part 4A. The Commissioner's view, as per the 100A ruling, is that this circular flow of funds is highly contrived. The apparent object is to avoid the additional tax that would be payable if the trust accumulated the income. In reality, there is no flow such as all the while the cash never actually goes to AITCS. Justice Logan at first instance decided in favour of the taxpayer on 100A and Part 4A. Following the approach of Justice Hill in East Finchley, Justice Logan considered that the reimbursement agreement must precede the present entitlement of the beneficiary. And Logan thought this was not satisfied because the evidence did not show that the parties had given thought to paying a franked dividend at the time the present entitlement was created in June 2012. Justice Logan's view on the alleged temporal sequence was conceded by the Commissioner on appeal. However, it would have been worthwhile for the Commissioner to contest this point in the full court because it has never been properly considered having regard to the purpose of 100A and would have paved the way for 100A to succeed in both 2012 and 2013. The supposed temporal requirement as applied contains an unstated assumption which potentially can be undone, namely that it is only the date the present entitlement is declared that is material. However, on first principles, present entitlement means a legal right to demand payment from the trustee. And it is a continuing right that subsists until it is discharged by payment. Conceptualized this way, the present entitlement can readily be viewed as arising out of a reimbursement agreement here. For before the time the present entitlement was extinguished, the parties had certainly formed the intention that the economic benefit associated with it would be conferred on the trustee by way of a franked dividend. Putting the 2012 income year aside, for the 2013 income year, somewhat surprisingly, the judge considered that the payment of the dividend was conjectural despite the past practice. In both years, Justice Logan did consider there was a more limited understanding concerning the incorporation of AITCS as a beneficiary and the appointment of income to AITCS, but considered that this was an ordinary family or commercial dealing. Logan commented that the reference to ordinary in the expression refers to a dealing which contains no element of artificiality. Logan's statement of the legal test is consistent with Prestige and does not suggest that the exception could seriously undermine the integrity purpose of 100A. In terms of the application of this test to the facts, Logan took the view that it applied because Logan accepted that the new company, AITCS, was introduced to minimize Springer's retirement risks. Logan further held that the general anti-avoidance rule did not apply for multiple reasons. Before turning to the appeal, it should be noted that no serious criticism can be made of Justice Logan's statement of 100A precedent, of Logan's treatment of 100A precedents and his statements of legal tests, although the application of the law to the facts may be questionable in some respects. The important 100A precedents are cited: Raffland, Prestige, and Idlecroft. Next slide, please. So turning to the Guardian appeal, the Commissioner's appeal on 100A was confined to challenging Logan's conclusion for the 2013 income year when the arrangement was repeated. The full federal court dismissed the Commissioner's 100A appeal, but held that Part 4A applied for the 2013 year. Justice Hespy delivered the reasons Justices Perry and Darrington agreed. The full court held there was no agreement at all for 100A purposes and therefore did not consider the ordinary family or commercial dealing exception, although the court did undermine the factual basis for applying the exception here, as I'll note shortly. Justice Hespy at least disagreed with the trial judge's view that a frank dividend back to the trustee was conjectural. However, Hespy was not prepared to conclude that there was a sufficient understanding for 100A purposes. Hespy required evidence of a specific understanding between two or more parties that AITCS would pay a dividend to the trustee guardian. This is demanding because the more general submission made by the Commissioner was framed in terms of an understanding that guardian, the trustee, would benefit from the amount of AITCS's present entitlement and that Springer would ultimately benefit. Further, Hespy relied on Justice Hill's dictum in East Finchley to hold that where the reimbursement agreement is said to require payment by a beneficiary, here AITCS, the parties to the agreement must include the beneficiary or at least a representative or controller of that beneficiary. Then on that basis, Justice Hespy went on to demand evidence of a specific understanding between AITCS's controller, Springer, and guardian to pay a frank dividend, and this was said to be not established because on the evidence, the plan to pay a frank dividend was not communicated to Springer prior to the time of the present entitlement on 23 June 2013. Hespy also stated that there was no sufficient evidence of such an understanding amongst the advisors, and in any event, it couldn't be imputed to Springer. Now, the critique. In the full court, the inquiry and tests that were said to be required for enlivening the concept of reimbursement agreement under 100A are self-imposed, an unnecessary trap. The judgment makes inappropriate use of authorities and does not consider 100A decisions of high authority, which were directly relevant to the determination of the case. There are two specific critique points. First, the judgment presents a concept of agreement that is too narrow and inconsistent with 100A precedents. The judgment outlines propositions from case law that are represented as relevant to the meaning of agreement under 100A, but the cases are not appropriate sources. The first case cited with an extensive quote that discusses the meaning of arrangement is Re-Day, a 2007 High Court case, which is not about 100A tax avoidance. So it's not about 100A tax avoidance or tax, but a constitutional case on Senate eligibility. This statement refers to an arrangement being consensual and that there should be some adoption of it. Then strong emphasis is placed on the meaning of agreement from FCT and Lutovi, which is drawn from an entirely different tax context. It's not about tax avoidance, but the taxability of bonus shares under a former provision which referred to agreements or arrangements pursuant to which the shares are issued. That definition referred to agreements or arrangements, whether oral or in writing, that are entered into and appeared to contemplate arm's length transactions virtually akin to contract. These authorities are the apparent basis for the proposition stated in Hespe's judgment that an understanding for 100A purposes must reflect a common intention or consensus existing between at least two parties. The problem with resorting to case law from outside the 100A setting is that the words of 100A are being given a constrained meaning that is not informed by the provision's central purpose of addressing trust tax avoidance. For the meaning of agreement for 100A purposes, the approach that should have been taken is to examine the 100A authorities, Prestige, Graffland, and Idlecroft. In all of these decisions, we find statements that the language of 100A should be interpreted to give effect to its purpose. And this purposive broad approach is reflected in how the provision was applied in those cases. In Raffland, what is striking is the absence of any kind of inquiry into agreement of the kind seen in Guardian. It would be recalled that Justice Kiefel, whose reasoning and decision was fully upheld in the High Court, did not require the Commissioner to even plead a reimbursement agreement per se. The series of steps comprising the tax avoidant plan was sufficient. Justice Kiefel, who extensively relies on Prestige, makes the point that a series of steps was also accepted in Prestige and notes that Prestige took the position that a reimbursement agreement should not be viewed as a discrete transaction or transactions divorced from the context of the overall arrangement. Kiefel further comments that the approach taken in Prestige is the only way in which the section can have a meaningful operation, given the context. So we see that there are highly pertinent statements on how agreement in 100A should be interpreted in Prestige and Raffland. But Raffland was not cited or discussed once in the full court, and Prestige is briefly mentioned once for a specific point, but not at all for the key propositions it established, nor for its overall purposive approach. The second critique point, the statements in the judgment on a beneficiary needing to be a party to the reimbursement agreement do not consider what is the relevant authority, Idlecroft, full federal court. The full court in Guardian relies only on Justice Hill's dictum in East Finchley that a beneficiary ought to be a party to the agreement, at least when the alleged reimbursement agreement involves payment by the beneficiary. But these comments from East Finchley cannot be relied upon since Idlecroft. As noted earlier, the ratio of Idlecroft is that a beneficiary does not need to be a party to the reimbursement agreement, and the taxpayer's submission in Idlecroft, which appealed to East Finchley, was rejected in the clearest terms by the full federal court. Further, we should note the astute point made by the full court in Idlecroft that any notion that a beneficiary needs to be a party to the reimbursement agreement is actually directly inconsistent with Prestige, which held that a reimbursement agreement existed in relation to a trust that had not yet been formed. That is, where it would be impossible for a beneficiary to be a party. Anomalously, Idlecroft is not cited or discussed once in the full court's decision in Guardian, and it should be noted that the ratio of Idlecroft that a beneficiary does not need to be a party to the reimbursement agreement is stated with approval in the High Court plurality judgment in Raffland. Turning to B blood, but about nearly.
You're doing fine.
Okay, sure. Yeah.
It's very
Thank you. So, yeah, I'm going to briefly outline B blood before giving my view on whether Guardian could have been won. Okay, so briefly, B blood. The case involved deliberately creating a mismatch between trust taxable income and trust distributable income, something the ATO has been concerned about for many years. In simplified terms, advisors came up with a scheme under which 10 million of Blood's business profits were diverted to a trust by means of a fully franked deemed dividend, following a contrived share buyback arrangement. Just prior to this, the definition of trust income in the deed was opportunistically changed to correspond with the general law trust meaning, such that the deemed dividend was excluded from trust income and part of trust corpus. Then a new beneficiary was introduced, which was made presently entitled to a relatively minor amount of ordinary income, $300,000, the income for trust purposes. Because it was presently entitled to all of the trust income, it was assessed on all of the trust taxable income, including the 10 million deemed dividend retained in the trust, but the tax liability on that was wholly offset by franking credits attached to the dividend. At first instance, Justice Thorley held that 100A applied and the decision was upheld by the full federal court. The full court's approach in B blood is substantively different to that in Guardian, albeit there was some overlap in judicial personnel. The judgment is that of the whole court, Justices Mushinsky, Colvin and Hesby. In particular, a series of steps is accepted as constituting a reimbursement agreement. There is no comprehensive attempt to identify the parties to the agreement. One party was identified only to attribute a tax avoidant purpose. And the use of case law is more astute. Prestige, a key authority, is relied upon extensively, even though, again, disappointingly, there is no mention of Raffland. So, concluding remarks, could Guardian have been won on Section 100A? Yes, at least for the 2013 year. Even for the 2012 year, not contested on appeal, the 100A claim is arguable if we think the supposed temporal requirement can be defeated. Returning to 2013, there is a strong basis that the same court could have come to the conclusion that 100A applied if it had been directed to salient 100A authorities. The reason why that conclusion is possible with confidence is because of the factual findings the court was prepared to make in relation to the Part 4A claim. The Part 4A case succeeded for the 2013 income year. Here, the full court was prepared to accept that the series of steps beginning with the conferral of the present entitlement in AITCS had the dominant purpose of enabling Springer to obtain a tax benefit. It will be recalled that a series of steps was accepted as satisfying the reimbursement agreement requirement in Raffland. This approach is also seen in B blood. In Guardian, the full court's willingness to find a dominant tax avoidant purpose under Part 4A undermines the evidential basis for the ordinary family or commercial dealing exception under 100A. The full court rejected the trial judge's finding that the purpose of AITCS was wealth accumulation and asset protection because AITCS immediately used its share of trust income to pay a frank dividend back to the trustee. it is important to recognise that 100A could have worked in Guardian, because the legislative text of 100A is not hindered with the impediments that have rendered Part 4A ineffective in other cases. There is no need to show a dominant tax avoidant purpose. There is no need to establish a counterfactual under which more tax would have been paid. Also, we can note in Raffland, the Commissioner of Taxation actually withdrew their Part 4A argument at an early stage of the litigation and relied solely on 100A.
Wonderful. Thank you very much, Sonali. Well, we do have some time for questions, both in the room and for people online. We're going to go to gallery view. Is that what you're going to do in the Zoom? Otherwise, you're going to see us disappearing like Inception into a series of mirrors. So those of you who are with us, feel free to turn your camera on if you'd like. But otherwise, that's if anyone would like to ask a question, either anyone in the room or online. If you're online, perhaps raise your hand or make an observation. We've got a little bit of time for discussion. So while people are thinking about it, first of all, thank you. That is the most useful explanation of 100A and the authorities that I have ever heard. And it's really a fantastic reminder of how to think through judicial reasoning on these really technical sections. And in fact, your point about the sort of purpose element of construing that section, I think is rather interesting. I'm not aware, and I guess you haven't mentioned any cases where that ordinary family or commercial dealing exclusion has actually been applied or else at least considered by courts. Is that right?
You mean in the 100A cases?
In 100A, yeah. I guess in Prestige, they considered ordinary business commercial dealing.
Yes, it was considered in Prestige. The taxpayer argued ordinary commercial dealing, appealing to the sale of the business from Prestige to the trustee, and the full court rejected the submission, saying, and their view was with the ordinary dealing exception, you can't look at one step or discrete aspect. You can't argue sale of a business is an ordinary commercial event. You have to look at the whole arrangement, and the purpose was tax avoidance. Yes.
I might have missed it if you mentioned it. Was there reference to Guardian?
You mean did B blood refer to Guardian?
Yes. Yeah,
it's about the same time. Maybe, but no, I'm not sure. It's like that. These cases, it's pretty much virtually simultaneous, not exactly the same year, and the appeals. One came down in sort of February and the other in or late January and in June. So these sort of a tension between sort of the counterfactual view on whether there should be a counterfactual. I think with the first instance Guardian decision, and B blood just rejected the whole idea of a counterfactual, sort of the Part 4A idea about importing that into 100A. So yes, in terms of some of the same issues and attention, but it doesn't stay with me that there was really Guardian referred to. Yeah.
I've got another one if other people don't. You know, the way you've presented it is very stark that the federal court is not referring to Raftland, and sort of then seems very surprising. I mean, I'm obviously partly this might be because of how the cases have been argued. I don't know if you've had access to the submissions at all and whether it's worth having a look at that and seeing whether.
Yeah, that's a really good suggestion, because quite frankly, it's shocking. And I don't understand it because it's not like Raffland and it's not hard to discover. It's a High Court case. And Idlecroft, not mentioned once. And it is really the only case that has dealt with that party point. Yeah, it's very surprising, irregular.
I mean, and just taking that a bit further, I mean, I've probably been guilty of this too. Of course, Raffland is known as a sham case, and one of those very few cases where the doctrine of sham is actually considered and applied in the High Court, that full authority.
Yeah.
And although, as you say, Section 100A was actually necessary to get to the result once the sham was dealt with. But do you think that's coloured people's views of the decision?
Yeah, actually, that's a really good comment because when I presented this in June at the Queensland Tax Researchers Symposium, a tax colleague said to me afterwards, he was aware of Raffland, but said, did they really talk about agreement in Raffland? And okay, there is this key point here and that's why I kept emphasizing it. They rely on Kiefel, right? And she's the one that deals with agreement. So that's part of, I guess, the steps in my reasoning of the relevance of Raffland. But the thing is, so Raffland High Court holds that 100A applies. Look, that decision doesn't stand up unless you have to accept Kiefel's conclusions in order for the High Court decision to stand up. It is true that the High Court decision, it's actually like really brief. There's only a few paragraphs, just basically accepting Kiefel.
I have a perhaps quite basic or silly question, but what are the key differences between the idea of this reimbursement agreement for 100A and how we might conceptualize a scheme, I guess, for Part 4A, or are we really now just talking about, in substance, the same kind of thing?
I might just repeat the question just for the mic. We're not quite sure if it gets picked up. So yeah, the point is that we talk about scheme in Part 4A, obviously another anti-abundance rule, which has a broad definition in Section 177A. Are we really talking about the same thing here? What's the relationship between that and 100A?
Yeah, so I think scheme in Part 4A is really wide. And scheme in Part 4A can be even, it says in the legislation, it can be even one person. Now, Part 4A overall is the way it's been applied by judges. It's not, you wouldn't say it's wide in terms of there's just been so few the number of successful cases. So reimbursement agreement is a type of scheme. I mean, if we look at the legislative provisions, scheme in Part 4A is wider. But in relation to trust tax avoidance, 100A is more effective, has been, could be more effective, has been interpreted really liberally, purposive approach in Raffland. Yeah.
I guess it has that broad definition, but it does seem to require more than one party, I guess, to an arrangement or to something like that.
Yeah, perhaps.
You just said a series of steps. So can you maybe elaborate on that, this idea of the series of steps and where that comes from?
Yeah. Well, okay. So in Raffland and B Blood, sort of this series of steps, just the tax avoidant plan is considered enough. Now, say if we take Raffland, there's more than one person involved. But there's no, there's no sort of fixation about let's identify the parties, right? But there's more than one person, more than one actor. But then even with Guardian, there's more than one person involved. So yeah, I think 100A ought to have worked. Yeah, I guess maybe, yeah, I mean, in my actually published article, I did say that I did think that maybe you need 2 parties under 100A, maybe, yeah. But
I mean, perhaps you almost inevitably, given that you have a beneficiary who has a present entitlement and you have a trustee, you almost inevitably have those 2 parties, although they may not be the parties to the arrangement. As you point out, the beneficiary does not have to be kind of in the arrangement, as I understand the reasoning.
Yeah, I guess, and look, there's at least that one way in which Part 4A is broader, in that with the scheme, you can have just one party. And rely on Part 4A? Well, look.
So just the question was about whether, given Part 4A, do we really need 100A? Should we just give up these multiple rules? Yeah, with the sort of our knowledge of the case history, yes, you need 100A. I mean, it is not inevitable when you look at Part 4A that it should be so ineffective in practice, but it has been. So I looked at the Part 4A trust cases. There's, okay, so before this round, there's three cases where a trust is a core component of the alleged scheme under Part 4A. It does seem to suggest, doesn't it, that, I mean, perhaps this is what the drafters thought, that there are particular features of trusts and beneficiaries and the way that they interact that kind of calls for a particular approach. Yeah. And whilst if you read 100A, it's a bit of a nightmare when you look at it, but it has been interpreted liberally, and the sort of the basic idea of it, that there's a beneficiary who's made presently entitled, but economic benefit going to someone else, that just happens. So that is, the sort of the that's trust tax avoidance. That's the common way in which you see it. Trying to remember, is Cartier on appeal? You mean High Court? Yes. Not that I know. Does anyone know? The answer? Yeah. That a no? Or and maybe a few months ago. Yeah. Wondering if the commissioner was just happy about the Part 4A aspect, then I don't know. Yeah, I don't know. Yeah, a potentially good case for appeal. Yeah. Any other?
One more. Do you have a view on why the court in Guardian didn't follow any of the existing, or the existing 100A precedents? Why they didn't?
No, I think, I suspect they weren't directed to the authorities, because we see there's some overlap with the personnel in B blood, and even though Raflan's not cited, it's just, I would say it's sort of, there's no, it's not irregular, it's not negligent, it's it's extensive reliance on prestige. Yeah.
But again, the submissions might have a bit more.
Yes.
Or the hearing itself, I don't know, the transcript. One does have to pay usually to get transcript, but you never know.
Yeah, no, that's a really good idea. Yeah.
Andrew, and then Andrew in the room, and then if there was. Oh, okay. I might just you've put a comment in the chat, Michelle. Thank you. We can't read it. I'm just going to read it out. And if you'd like to elaborate on it from online, please do. You make the observation that Hesby seems to point towards not being able to move on section 100A because of the findings of fact by Logan J. What are your thoughts about that? So, of course, that was the appellate court, Logan J having found the facts at first instance.
Yes, yeah, I do recall a few instances, and also the comment made that in the judgment that this was not contested as glaringly improbable, some findings of fact. However, so 2012 was not contested. So if we look at 2013, but then, yeah, despite those comments, I think I see the problem with Guardian, the appeal decision, as pertaining to use of precedents, in the sense that you've got these cases from outside the tax context, outside the 100A context being relied upon. So, yeah, I noted that, but it's not. Yeah, I do see the problem as being with the use of the law in the Guardian appeal.
So perhaps she, if that is how Her Honour felt, that she couldn't apply it because of those findings of fact, that's probably unduly constrained, you think, given that the other authorities might have permitted its application.
I'm not sure. Yeah. Yeah.
And did you...
I was wondering whether or not some of the difficulties is it can't because it's almost like there's an attempt to apply in circumstances that weren't really constituted section effectively certain kinds of arrangements that existed that sequence in particular. Just wondering whether we really should be looking for a different solution to some of these cases.
Well, sometimes the taxpayers have made this point that the provision was intended to address these, trust stripping arrangements in the 70s, and what the judges have said in Prestige and subsequently is that whilst the provision certainly was contemplating those situations, it's not limited to that. But I actually don't think it's a problem to apply 100A to even some sort of family discretionary trust situations, which the Commissioner indicated that it could be used to say family context even, but where adult dependent child is made presently entitled to an amount which there's never any intention that they're to get it. And at least in the draft ruling, because the Commissioner did retreat with the finalised one, there, I don't see if the legislative words, which I think can apply to even, it doesn't matter what the context is, whether even a family situation where you've got a scenario where, the economic benefit is being enjoyed by someone other than the presently entitled beneficiary. I can't see any impediment to why 100A should not be used. So, yeah, maybe it wasn't intended to, but yeah.
Or that could in fact. My point is more with this draft, with certain kinds of arrangements, mind, which can in some ways restrict, not deliberately, but causing to not flex sufficiently to be able to meet some of these cases, but perhaps we should two apart ways. It's probably a deep conversation.
Yeah.
I might just
Mm.
briefly say
Mm.
that whether or not the intention from the schemes in the 70s, was to go broader, the drafting may have been affected perhaps
It's possible.
by the schemes that were
Yeah.
in contemplation
Yeah.
at the time.
Yeah.
And that might make
yeah.
it harder for us
Yeah.
to interpret now, I suppose.
No, actually, I think that, probably. I think that's right. Because if we look at the provision, for one thing, it's incredibly complex, right? And but I think maybe the solution to that is to rewrite 100A rather than,
Is to what?
to maybe just to simplify.
Just to
some
reform
of them.
100A. So there's an
Yeah.
interesting question as to whether there should
Yeah.
still be a special trust targeted integrity rule, but perhaps because of the nature of the trust relationship or something, whether 100A fully, mind you, you have persuaded me that the courts haven't cited all the authorities that they might possibly look to help consider these problems and work out what the section means. So I suppose that point still stands, I would say. Well, thank you all very much. Thank you for a very stimulating paper. Thanks for joining us online. And we'll check the recording. Hopefully the mic came in and out a little bit, but hopefully it's good. And I think we're able to circulate the slides in due course to people who registered for the seminar. Thanks and see you next time. Thank you very much, Sonali.